Welcome to Business Law 1 class. Today we look at Unit 2, Theoretical Foundations, Formation and Classification of Contracts. Section 1 of Unit 2, the definition and theoretical foundations of contracts. By the end of this session, you should be able to define what contract is, explain the theoretical foundation of contracts. Now, what is contract? Contract is an agreement between two parties who have capacity for a price measured in terms of money, effort, forbearance, or exchange of promises, which agreement is intended to bind the parties and is enforceable by the court or a court of law. From the definition, you can deduce the elements of a valid contract. So every contract should contain key ingredients. Now, from the definition, you saw that contract is an agreement. Contract is an agreement. It is the offer and acceptance that constitutes agreement. So when the offeree accepts the offer made by the offeror, then there's an agreement. You also have the consideration component of a contract. The consideration component is the price element in a contract. It could be cash, or it can be effort, it can be forbearance, that's not to do something, or serious exchange of promises. Now, you also saw that there should be elements of capacity. So capacity is your ability to enter into a binding contract. We also indicated that there should be intention to create legal relation. It means that the parties must have the intention that if any of the parties breaches the contract, he or she will go to court to enforce his or her rights. We also have the issue of enforceability of contract. Here it simply means that it should be a contract that can be enforced by the court. And here you have to know that only lawful contracts will be enforced by the court. Contracts that are tainted by illegality will not be enforced by the court. Theoretical foundations of law of contracts. The first foundation or element we consider is sanctity of contract. Sanctity of contract here simply means that the court should consider the contract that the parties have entered to be sacred or perfect, and the court should not intervene in the contract that the parties have entered. The only circumstance under which the court will intervene is when that contract is tainted with any of the vitiating factors. For instance, fraud, undue influence, unconscionability, duress, misrepresentation. When those elements destroy the legality of the contract, the court may be invited to set those contracts aside and to some extent declare it void, especially when it involves illegality or fraudulent acts from one of the parties. We also have freedom of contract. Freedom of contract here simply means that the parties have the free will to enter into any contract of their choice. It means that the contract should be entered voluntarily by the parties, No one should force anyone to enter into a contract. Therefore, you have the freedom to enter into any contract of your choice. That general provision is subject to two main limitations. One, we are saying that the person should have, or the parties should have capacity. Capacity is the ability of a party to enter into a binding contract. So the person should have capacity. Two, the second limitation is that the contract should be lawful. The contract should be lawful. So your freedom of entry into any contract of your choice is subject to these two limitations. The third one you want to consider is contracting parties beware. Contracting parties beware, or a contracting party beware. Here it means that all the parties that are entering into a contract should do their investigation well before they enter into a contract. Any contract that a reasonable person, any search or any check that a reasonable person will do before entering into a contract, the parties must do so or do those checks. Now here it kind of principle, caveat emptor, caveat emptor, let the buyer beware, and caveat venditor, let the seller beware. So the parties must satisfy that indeed they are dealing with the right persons and the items that they are buying, it is of quality of the same standard, of the standard they are looking for. You also have the protection of the innocent third party. That is the innocent third party purchaser. Here the law simple states that if a third party enters into a contract with another person, with that third party having notice of the defective title of the seller, then the law should come to the aid of the innocent third party purchaser to protect him or her. So in the case of CAD v. ADB, the court held that the third party who purchased the vehicle without the notice of the defective title of the seller is entitled to the product because the third party has provided sufficient consideration. The next element you want to consider is reasonableness. Reasonableness is the friend of the law. Now, when there's a contract before the court and there's ambiguity in the contract, the court will use the reasonable man's standard. The reasonable man's standard is the standard of a reasonable man. And a reasonable man, in this case, is a person in the society who might have exercised the average skills, judgment in entry into a contract. What will be reasonable in one circumstance will not be reasonable in another circumstance. So reasonableness will be based on the fact of each case. The court may consider or apply reasonableness in granting quantum merit and awarding damages as well. When it comes to mitigation of damages, the court will consider reasonableness. What is the step that the innocent party took to reduce the losses? Is it reasonable or not? We also have the element of no tolerance for fraud. The law is intolerance of fraud. What it means that any fraud element in a contract brings that contract to an end. Fraud omnia vitiate, meaning that fraud destroys the beauty or the legality of the contract. So contract that is tainted with fraud is void. Therefore, the court will not come to the aid of a person who has induced another person to enter into a contract with fraud. Session summary. In this session, we have stated and explained 6 theoretical foundations of contract, namely the freedom of contract, sanctity of contract, contracting party beware, the protection of the innocent third-party purchaser, and intolerance of fraud. Thank you, and have a nice day.